So this week's topic is basically looking at people who, for biological reasons, are unable to have their own children and therefore are looking to either foster or adopt, or maybe even use their own genetics to have their own children. So I'll briefly look at what fostering is. So fostering itself is an arrangement between two parties where a child is placed with a foster parent, and the foster parent, depending on what the arrangements are, either under the Children Act in relation to care proceedings, which is a public law, or under private arrangements, which sometimes may be informal or maybe formal because written agreements are done to provide care for this child. The foster parent usually do not have parental responsibility unless she has or he has specifically been given that by the courts, or there has been an arrangement in place where we've got a parental responsibility agreement, which is filed and sealed in court. So again, that's something for you to think about. You can do that through the local authorities, or you can do that on a private basis. The second part, which is adoption. Adoption itself, it's a very complex area of law because there are various requirements within the Children and Adoption Act, which expects that certain processes and procedures are followed. So the first thing that you must bear in mind is if the adoption is in the UK, then you need to be assessed by an adoption agency. It used to be the local authority. They don't offer those services anymore. So that's done by a private adoption agency who are trained in this area, and they will assess your background, your medical evidence, your income, and also your criminal background, your work status, your living condition, and also they will look at your medicals and see whether it is appropriate for the child to be placed with you. In the UK, you may have a trial period, and then where that works, then you can finally go to court and obtain the adoption order. Invariably, most of you will be looking outside the UK, for example, Ghana, Nigeria, Sierra Leone. But what you need to bear in mind is that if it's an international adoption, then the inter-country adoption processes and procedures and guidance comes into place, which is that the country must either be on the designated list, under the designated list of 2014. Previously it was the 1973 and the 1993, and now we have the 2014 designated list. Or it must be a Hague country. So a Hague country will be a country that is a signatory to the Hague Convention for the Protection of Children, including adoption. If the country is a signatory, then clearly its adoption is recognized under UK law. If the country is not a signatory, then it must be on the designated list of 2014. However, there are instances where the country may not be on the designated list, it may not be a Hague signatory, and therefore its adoption will be what we call a de facto adoption. So a de facto, as you know, is a fact. So it's a fact that exists, and paragraph 309A of the immigration rules recognizes that. But if it's a Hague country like Ghana, then again, you need to go through the assessment processes, which is usually done unless you're physically present in Ghana when it was being done and have lived in Ghana for at least 6 months. Then that will be done in Ghana. There's about biography forms to complete. You need to also buy a form from the department. You will be seen by social welfare officers, and your lawyer will then file an application in court. The judges sometimes will speak to the child and make sure that there is what we call parental consent. Just bear in mind that if the child is within the family, then the requirements are a bit liberal. But if the person is not within the family, then again, the requirements are a bit stringent. Again, your background should be known. The home study report must be done it can be very expensive. The final one is the surrogacy rules. Now, we don't have a simplified, agreed definition of surrogacy under international law. So what may be surrogacy in the UK may not be in Ghana. First of all, just remember that the Ghanaian law does not have surrogacy rules. So even if you go through surrogacy, surrogacy is a biological process where another woman who may have biological connection with a child or may not have biological connection with a baby gives birth, carries and gives birth to a child, which is the Embryology and Fertilization Fertilization Act. And the Surrogacy Act is what we look at. But just again, remember that in Ghana, we don't have surrogacy rules. So what the UK law clearly says is that if the commissioning couple, so I say commissioning couple, this will be the couple who have come together. So maybe a husband and a wife or a partner. Unfortunately, the woman is not able to have a child, or maybe that the man is not able to produce sperms to fertilize the woman's egg. So the woman's egg is then fertilized by another man and then inseminated into someone. There are also rules around game. It's called game as the gamete law. It's also another complex area. If the woman who is a surrogate mother and a carrier is carrying the baby and she's married under British law, under the British Nationality Act of 81, Section 50A, will apply, which means that the child will be the child of the woman and then her husband. If the woman who is a carrier hasn't got a husband, then whoever fertilized the egg will be the father of the child. Just remember that the mother who produced the egg is never the mother of the child, unless, of course, they've gone through the processes. The surrogacy agreement can be an agreement between two parties or three parties, where clearly the fee that is paid to ensure that a pregnancy is carried to its full term. Is not a remuneration, it is a compensation. So compensation is basically that you won't incur costs because you're two, you're not one. You've got a child, your medical needs, you may have to buy extra clothing, you may even stop working, so that has to be compensated. But in Ghana, they do it. They do the artificial insemination. It's done successfully. I think Ghana is one of the countries in Africa where artificial insemination of fertilization is very, very successful. Usually you may even have multiple births, and I think some people prefer that. But in Ghana, if that's what you're doing, you will need to get a court order to then give the children back to you. But the commissioning couple, if the man is a person who produces sperm, then the Ghanaian law will recognize the man as a father of the child. And if the woman is not married, the UK law will also recognize the man as a father of the child. These are very complex area of law. I'm not asking anyone to go and do trial and error. This is not somebody who's trying to fix a light bulb or who is pouring oil in a car or filling the car with a petrol. These are very, very complex area of law, and only few people specialize in that area, even in Ghana. And in the UK, it's a specialist area of law. And I'll always advise you that if you're going to someone to advise you about surrogacy, adoption, fostering, and also immigration, find somebody who has accreditation by the Law Society or the SRA in family law and also in immigration, because it is a very, very complex area of law. But as I've said, it brings joy and happiness to couples who otherwise would not have a child of their own. We've helped many couples to do that. The kids have come here successfully, some with British passports, some with indefinite leave under 310 or even under 297, and some even exceptionally under the immigration rules. But it can be done. And I also urge everyone that, if you're looking to have a child of your own and you can produce egg or the man can produce sperms, remember that surrogacy is a path that you can choose. And on this path, I say, good luck to you in your journey to have a child of your own.